What should supporters and plaintiffs, a part of the class action, expect in the next coming weeks?
Not much, quite frankly, other than what I say, these motions to dismiss. I mean, I know Dominion Voting Systems is going to be filing a motion to dismiss. I'm sure Facebook will be filing a motion to dismiss. And that's relatively common. I mean, it's probably par for the course in federal court. You file a motion to dismiss. It's part of the procedure. Now, just as sure that these entities are going to be threatening Rule 11, which is really a prohibition against filing frivolous lawsuits. This is not a frivolous lawsuit. I know what a frivolous lawsuit looks like, and you can imagine what a frivolous lawsuit looks like. It's typically a pro se plaintiff. We always joke that sometimes a pro se plaintiff will put a lien on an IRS's agent's house or something like that. Well, that could be considered frivolous. You see a lot of medical malpractice claims where you can't get a doctor to testify for the plaintiff, even though the plaintiff might think that he or she is really hurt by this other professional. Well, if you can't get an expert to agree with you, that could be considered frivolous. So I know what a frivolous lawsuit looks like, and this is just not one of them. Plus, it's very common for complaints to be amended, and we anticipate filing an amended complaint. The plaintiffs can look forward to that in the next couple of weeks, that's for sure.
How much are the damages and what do they represent?
Well, in a 1983 action, if a constitutional right violation is determined, well, then the law is very clear that it has to at least be $1. And that sounds a little ridiculous, but the law encourages these types of suits to specifically prohibit the behavior in the case and to send a message to others. So in this regard, the attorney that's forwarding a case can be an attorney general from a state, but if it's a private attorney such as myself and Mr. Walker, we're called private attorney generals. And so attorney's fees could be awarded upon a successful prosecution of the case. We don't think that the damage is $1. We think that the damage to each voter is significant. Even back in December, when there was some talk of the 12th Amendment or the Supreme Court becoming involved, all that went away. That just didn't materialize. So we really are just talking about damages to the voter. And so if there's 160 million registered voters and the damage is $100 per registered voter, well, that could be $11.6 billion. In our complaint, we used the rate of $1,000 per registered voter. That's $160 billion. So the cover sheet indicates a request for $160 billion, which would be $1,000 for each registered voter in the country. Now, as things have progressed and the country is a breath away from civil war, all based upon an election that, right or wrong, no one has any faith in, or at least a substantial portion of the population doesn't have any faith in, we're beginning to wonder whether or not that's a gross underestimate of how each registered voter has actually been damaged. Maybe it's more than $1,000 per registered voter. That's up to the jury. That's up to the jury. Not the judge. The judge could dismiss the case. But once we get into requiring the defendants to answer and discovery and setting the matter for trial, that's a jury question. As it is in every case. As it is in every case.